thank you very much. But how much about the conference have you seen or read? Anything that you've seen in terms of sessions?
First of all, I want to congratulate you for the tremendous work you are doing for the promotion of mediation and for the further instruction of mediators. It is absolutely superb what you are doing. 90 sessions, it is really something. And then I would like to thank you very much for having invited me to be one of the panelists and for giving me the opportunity to mention some dispositions of Greek legislation, among others, which might be of interest because possibly they are different compared to other legislations. Now, to answer your questions, I must say that unfortunately, I have not been able to listen to many sessions because I was overloaded myself organizing every Monday lectures about mediations with speakers, mediators from all over the world, and you will be one of the next I will invite in September when we will start again. So this was also a lot of job which I had to do. And on the other hand, I am organized also still one more on Monday, then we stop for some summer, mock mediations with the participation of accredited mediators and scenarios which I write myself. Mm-hmm. So it is, you can see that it is rather difficult for me, but I have followed parts, small parts, and it is wonderful. I want to say that what Cheryl said, although, and I would like to have her address because I would like to thank her. What she said and exposed, although not directly connected to mediation or not only to mediation, is something which applies to all sectors of our life. Yep. I follow philosophy lessons and yoga lessons, and what she said is perfectly known, not perfectly, is known to me, and I am pretty sure it is perfectly advisable to follow her advices. So be so kind to send me her email so as I can congratulate her and thank her.
Thing is that what is going to happen, Catherine, is that I've sent you the link to the schedule of the conference. In that, there is a sheet there's a sheet of the panelists. So actually, everyone's detail is there. You just have to click on it. You'll get there the LinkedIn address. So if you go to Sherry, you can actually click on Sherry and you can get her details there. So I made it life very easy for all of you. You can connect with each other. So it's all here in the sheet. But,
excellent. Thank you very much, Vikram.
And what I do for a second, I'll just put up the poster of the conference so that people know this is what we're talking about. And of course, 18th of May to 30th June. Tomorrow is the last day. We have one session in the morning at 10 o'clock India time on mediation and restorative justice in Islam. And after that, we have a closing session and the 7 o'clock session, which you, of course, Catherine, you must attend on the last day that we have. So that's the important part. And beyond that, on philosophy, what you said, interested in philosophy, we had a session on Socrates and mediation. I don't know whether you got to see it. It's lying on the YouTube channel, so you can search Mediator Vikram, Socrates and mediation. Yeah. So that was a very interesting session. So the idea is to bring in from every aspect. So bring philosophy in and all that. So that was one interesting session that I will send you the link of. I can send you that link. So okay. Catherine.
Thank you.
So Catherine, you'll have to tell us about yourself. You'll have to tell us about yourself and then we take the topic forward. So please.
Okay. I am an accredited mediator. I have been a lawyer for many, many years, a lawyer of the Athens Bar Association. And since the 10 last years, I have dedicated myself to mediation. I was trained in 2008, and in 2013, I was trained as a mediator's trainer. Since 2020, I am a member of the Central Commission of Mediation of the Ministry of Justice and of 4 other sub-commissions dealing with important matters, such as, for instance, the granting of licenses, operation licenses to initiating mediators, among others. And I am also, since it was formed in 2010, I am the chairwoman or the president of the Hellenic Union of Mediators. We are organizing a lot of things, seeking to make mediation known to the broad public. I hope that we have succeeded, at least to a small degree, and we continue to make efforts. This is a short presentation of mine, and I am at your disposition to start speaking about the topic whenever you want.
No, absolutely. You can, at some point, maybe you can tell us what all you're doing in relation to promotion of mediation. That definitely will be interesting, so that I can also pick up something from there. But otherwise, we can go straight to the topic. So topic is, of course, the evolution of mediation in the European Union. So please. You can go ahead. Yeah.
So, to start with, I must say that the access to justice is a very important element, a very important notion to the European Union. It is provided in the European Treaty for the Protection of the Human Rights and the Fundamental Freedoms, which was signed in Rome in 1950. It is repeated in a chart which was signed 50 years later in 2000 in Nice, France, and which is called Chart of Fundamental Rights of the European Union. Both texts provide that any person, either physical or legal entity, has the right to have access to justice and to have his case heard by a tribunal legally formed, and to have a judgment in a rational period of time without having to wait indefinitely regarding a judgment. Unfortunately, this is not what happened. Since 1980, a tremendous augmentation of the cases was noticed both in the United States and in the European Union. The courts are since then overloaded, and every year they become more and more overloaded, and the time needed for a judgment to be rendered becomes the more and more long. This is not cost effective, this is not time effective, and in some cases, the judgment becomes useless because the party might have died or the witnesses might have died, and the trial might have lasted for 10 years. And at the end, we have nothing at all. In the decade of 1960, or more precisely in 1960, there was an act in the United States called the Civil Rights Act, which provided for amicable settlement of disputes, but only for disputes regarding neighborhood. So this was very limited. Then for 20 years, we had nothing. In 1980, the European Union started to turn towards alternative dispute resolution methods or moyens alternatifs de résolution des conflits, MARC in French, providing, however, that these alternative dispute resolution methods should not prevent any person to have recourse to the courts. The Council of Europe, in many texts such recommendations and others, made reference to alternative dispute resolution methods such as mediation, arbitration, settlement by ombudsman, etc. This was determined, but it is very important to notice that, as a matter of fact, all these ADR methods, all the directives, all the resolutions issued by the European Union and its organs, its authorities, concerned consumers' dispute. And one could ask why only consumer disputes? Because these disputes are usually a small object. The amount involved is not high, not justifying the expensive court proceedings, not justifying the people involved to wait such a long time to have a judgment. So first, these disputes were dealt with, and many of the papers issued by the European Union concern only the consumer's dispute. I start with the Green Paper, which was issued in 1993. You may see that since 1980, when movements started to be done towards alternative dispute resolutions, 13 years have elapsed before we had something concrete, a paper. In 1998, the European Commission issued an announcement regarding the out-of-court solution of consumer disputes again, as well as a recommendation in respect to the rules which must govern the institution providing the out-of-court solution of consumers' disputes. In 1998, during the meeting of the European Council in Vienna, held in December 11th and 12th, a resolution was issued regarding the promotion of the use of ADR methods. The first time we heard it was dealt with disputes being not only consumer disputes, but also civil and commercial disputes, was in Tampere of Finland in 1999, when a similar resolution as the precedent was issued during the meeting of the European Council held in Tampere, by means of which the European Council invited the member states to set forth out-of-court processes seeking to facilitate the access to justice. It was the first time, as I said before, that reference to out-of-court settlement of dispute methods was not limited to the solution of consumer disputes. Thereafter, by a resolution dated June 6, 2000, the European Council invited the European Commission to put in force rules seeking to govern ADR methods in a fair and efficient way. Then, in 2000, Directive 31 was issued about electronic trade. It was the first attempt of a legal text mentioning the digital way of solving disputes. But this directive also is specialized since it concerns only specific kinds of disputes, and more precisely disputes accruing out from the granting of services in the field of the society of information, for which the possibility of settlement exclusively by the appropriate electronic means is available. On April 4, 2001, the European Commission issued Recommendation 31, requesting the member states to respect the principles of impartiality, transparency, and effectiveness of justice by all the public institutions offering processes of out-of-court settlement of consumers' disputes once more. To be noted that this directive set forth the principles which govern nowadays all the ADR methods and more particularly mediation. On April 19 of the year 2002, the European Commission submitted, The European Commission submitted the final text of the Green Paper regarding ADR methods for the settlement of civil and commercial disputes. Now it is the first time we speak clearly about the solution by means of ADR regarding civil and commercial disputes. And during the summit of the European Council held in Brussels in April 2007, a resolution was issued regarding the out-of-court settlement of consumer disputes, ending merely to an advice to the member states to encourage the setting up of new programs of dispute settlements, even in respect to dispute not connected to commercial transaction and commerce in general. There are other directives regarding traders' disputes and the consumers' disputes, but I will go straight forward to the evolution of mediation in the European states to tell you that all these documents I have mentioned ended to the promulgation of Directive 2008, number 52, and I will shortly analyze the main articles of this directive and compare them to Greek legislation on mediation. As a matter of fact, mediation was known in the European countries and used many years before Directive 52 of the year 2008 was promulgated. It was not regulated in such a detailed way, but it was very well known. And to be more precise, mediation, as you stated before, Vikram, was known very well since the ancient years. The solution, the amicable solution of disputes is something which was practiced all over Greece. And I can tell you that it is very interesting to notice that up to now, in the island of Crete, there is a way to settle the disputes which are very hard and last for generations by killing between two families. And each family kills members of the other. And the other family must kill members of the first family. So this is really something which has to disappear. It is mitigated by what we call sasmos. Sasmos is a Greek word, of course, which accrues out of the verb siazo, which means I correct. So I correct things by means of seismos. To come back to the directive,
But Krishnan, Catherine, can I come in here 1 second? In my symposium last year, which was that on mediation in our culture and traditions, there was someone from Romania, Christian Chereji, who's actually researched, he's done research in Crete. So that session is also should be interesting for you. So I'll send you the link to that also. He's worked in Crete itself.
Oh,
yeah, so he's actually lived there to see how they function. He's done very good work there too, and he explained it very well.
Thank you very much. It is very interesting because the Pantheon University has arranged for some 45 mediators. We have written a book. It is a collective work. And among others, I have written in this book a chapter regarding seismos. So it will be very helpful to have this document also. Thank you so much. So to come back to the directive, I can say I'm very impressed, Vikram, that you are aware about this seismos.
People
Indeed,
make me aware from every part of the world. They make me aware of all these things. So
it is very important. Yes. So before the directive of 2008, mediation was applied, as I said before, and more precisely, there was a UNCITRAL model law which was drafted by the International Commission of Disputes. Allow me to give you the United Nations Commission for International Trade Law, UNCITRAL, drafted a model of law which was amended in 2018, and it is called now UNCITRAL Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation. One can see very easily the importance and the reason, possibly the reason, of the change of the name because of the Singapore Convention, which concerns the enforcement of settlement agreements resulting from mediation. So many states followed this model law, and this model law granted to the various states which would follow it the possibility to provide that its dispositions would apply not only to transborder disputes, but also to internal domestic disputes. And the model law suggested the wording of the articles which should be included in the national legislation if it decided to extend the application of the model law to domestic disputes. Further, the model law provided that for many issues which it does not regulate, the various states were free to provide how they would be treated. For instance, the interruption of the prescription and the time limitation. The states wanting to include such dispositions in their local legislation had to add, of course, articles in this respect, relevant articles in this respect, the wording of which was contained in the model law, facilitating thus the uniformity of the wording. The states member had to implement the directive no later than May 21, 2011. Greece has implemented the directive. I come now to Greece by saying that Greece has implemented the directive in December 2012, 2010, by means of Law 3898, introducing for the first time an organized legal system regarding mediation applicable to trans-border disputes, but providing also that these dispositions would apply to internal or domestic disputes. Let's come back, before continuing with Greek legislation, let's come back to the directive of the European Union to see what its main articles provide. In Article 1, it is clarified that the directive applies to civil and commercial transborder disputes, provide, as I said before, that it could be extended also to domestic disputes. The main characteristic of the disputes ranking for mediation, both according to the European directive and to all the Greek legislation, I say all the Greek legislation because Law 3898 was followed by two other laws about which I will speak later. So the main characteristic of a dispute, commercial or civil, ranking for mediation is that the parties involved must have the right to dispose freely of the object. The same article enumerates the disputes which cannot be submitted to the mediation, and which are, as it is the case of almost all European states, the tax, customs, administrative disputes, as well as all the disputes having as object the responsibility of the state due to acts or omissions committed during the exercise of its public authority. That is, the acts iure imperii. I must say at this point that the way in which the directive has regulated this matter is much more appropriate and efficient than the one Greek legislation followed, which provides that any dispute in which the state or state authorities are involved, regardless to which authority they have exercised, regardless, either they have acted iure imperii or iure gestionis, cannot be submitted to mediation. To my opinion, this is not something which can help, because there are many cases in which the state or state authorities act in an illegal way, let's say, or omit to act in cases which are not contained, which cannot be included in the frame of the public authority. For instance, the state signs a contract with a supplier for him to supply the states with XYZ objects. If the contract is not respected by the state must pay an indemnification to the supplier. It's so simple as that. Why to exonerate the state from the dispute from the possibility to have it solved by means of mediation? In paragraph 2, the directive provides which are the cases where a dispute can be considered as a transborder one. The main characteristic is that the place of residence of at least one party is not the same as the one of the other parties. The place of the domicile or the permanent residence. But this difference of domicile or residence must exist in specific points, in specific times, which are when the parties agree to have recourse to mediation. After the mediation has arisen, then we have to check whether their domicile or residence is in the same state member or not. Second, when mediation has been ordered by a court, when there is an obligation to mediate based on the national legislation, and when the parties are invited to have recourse to mediation according to what is provided in the directive. As a matter of fact, these criteria, which I have mentioned, refer not only to transborder disputes, but also to domestic disputes if a national legislation has decided to extend the application of the dispositions of the directive to domestic dispute. Another case where a dispute is considered as a transborder one, regardless to the place of domicile or residence of the parties, is the one when, after mediation has been conducted and is achieved, but failed, legal proceedings or arbitration are instigated in a member state other than the one where the mediation has taken place. Such kind of disputes are considered to be transborder. And the question is why? The answer is that the European legislator wanted to make of these disputes transborder ones to have the principles, especially of transparency and more specifically of confidentiality, applicable to them as well. Article 3 and 4 set forth the definition of mediation and the definition of mediator. I think that there is no reason for me to repeat these definitions since they are almost the same all over the world.
Actually, Catherine, the definition actually is the whole thing, because everyone's picked up different definitions. And I keep saying the definition in the Singapore Convention for me is the best definition that you can give. So if there is a different one, we should have a look at it. I think it'd be interesting.
Okay, thank you. Thank you. So mediation is defined as a structured process. It is a common definition included in the directive and also in the national legislations, usually. It is stated in this Article 3 that mediation as a structured process includes also mediation performed by a judge who has not dealt with possible judicial proceedings related to the dispute under consideration. I would like to say at this point that in many states, including Greece, judges are authorized to conduct mediation. But they are not mediators, they are not accredited. They are not even trained as mediators. In Greece, we do not call the judicial mediation. Mediation, in Greek, mediation is called diamesολάβηση. The judicial mediation is called Mesolavici, to distinguish these two kinds of mediations.
But what does it translate into,
So,
both of them? What do they translate into English if you have to translate both the terms?
It would be difficult because diamesolavici means mediation between. Between is included in the word mediation itself. And mesolavici is mediation between again. You know, Greek is a very rich language, but in some cases we cannot translate. So the most efficient way to make to distinguish these two kinds of mediation is to say mediation and judicial mediation. This is what I would propose. The judge conducting the mediation, as I said before, is not a mediator, and the prerequisite is that he must not have dealt with this case in any capacity whatsoever before. Every year or every 2 years, the president of the Court of First Instance and the president of the Court of Appeals designate 2 judges who will conduct the mediation, the judicial mediation, at the request of the litigants. To be noted, here I would like to make a parenthesis to state that the attempts for conciliation done by the judge during the hearing of the case, before he starts listening to the case, are not included in the judicial mediation. This is obvious. Now, as to the definition of the mediator is any third person requested to conduct a mediation in an appropriate, efficient, and impartial way, regardless to his denomination or his profession in a state member, and regardless of the way in which he was appointed or has undertaken to perform said mediation. Here we should stop and examine what happened in Greece when the first law 3898 of 2010, as I stated before, was promulgated. This law provided that to be a mediator, to be trained and then accredited, a person should be a lawyer. But the European Commission has considered that by doing so, Greece has violated another directive providing the free exercise of professions in the states of the European Union. So in 2014, Greece has modified the law and has suppressed this prerequisite, has deleted this prerequisite. Now, there are some other points which I do not think they would be of interest to the persons listening to us, but I can summarize very briefly to say that the European Union was not satisfied with Greece because Greek legislation provided for the institutions educating mediators to be only legal entities which had to be formed mandatorily by at least one bar association and at least one chamber of commerce, of industry, or whatever chamber located in Greece. And the European Commission considered that this was restrictive and contrary to another directive. And the European Commission has also considered that by asking for the persons educated abroad as mediators to produce in Greece additional documents showing their capacity as mediators and proving also that they had already participated to 3 mediation processes at least, that Greece has violated again another directive. And this is why by the last law 4640 of 2019, Greece has provided that the institutions providing education of mediator services can be even physical persons or legal entities formed by whoever. And also it has reduced the prerequisites for a person's educated abroad to be recognized in Greece, to be accredited by the Greek Ministry of Justice. So this was in brief. Excuse me, Vikram, but I want to stick on the most interesting points.
Yeah.
Now, it is worthwhile to mention that most of the European countries do not provide strict conditions of training of mediators. I was very surprised to listen to colleagues coming, for instance, from the UK, saying that no, mediators are not trained. They are not accredited. They can be trained by Chartered Institute of Arbitrators of London or by Center of Effective Dispute Resolution, CRB and CIDR, if they want so to add something more to their bio, which could attract clientele. So it is something strange to me and peculiar to have so many countries, because the UK is not the only country which overcome in a way the dispositions of the directive, and they have not any warning from the European Union to change the situation. It is very strange to me. And also, I take the liberty to say, very dangerous to have people who are not trained undertake to conduct mediation, as it is the case in the states where they have not the obligation to be trained, because they take the responsibility to conduct correctly the mediation. Yes, but this is not enough, to my opinion, at least.
Catherine, look, I'm on the other side of this. Okay, so I won't get into this. I'm on the other side. I actually believe that we have to be able to keep that flexibility, only because, first of all, the kind of size of countries like us, say India, is so huge that to even say that you can train, it means that you have to have trainers. First of all, I feel that let's not call it training, let's call it skill development, because people who have the skill, let's take them forward. So I'm on that argument there. And the numbers that we need are huge. I mean, huge numbers. To be able to get there, you will be creating a whole system where anyone would be able to go out and say, we'll train and we can certify, and we'll give that will go into a totally different direction. That's what I believe.
You are absolutely right. I agree with you. And this is a phenomenon which we can see in Greece, where there are so many institutions educating mediators, which is unbelievable. But what I wanted to say and stick on is that in such a case, the directive should change, because it cannot be contested that the directive provides education of the mediation, of the mediators. So let's abrogate this obligation, and okay, very well.
Absolutely. Yeah.
Okay. But Vikram, do you agree with me that even then it will be a mess, because everyone will pretend to be a mediator?
Like
Not
me,
everyone.
Like me, I'm in that category. I am the one on that category. I keep fighting for this side that look, we are there, we exist. And for us, the certification is from the user. And if the user certifies us and tells other people about us, we must be doing a good job. Let the market decide as what people say. Because on the other side, what I've seen is that people are being brought into, whether it's a profession or not, we've debated that, but being brought into mediation through this certification process, user experience is not happening the way we would want it to happen. People are getting a totally different idea of mediation because there is a certain box which they take. It's the mindset which is required, that mediator mindset. So my focus, Catherine, is now let's go out, ask people who those people are whom you think have the mediator mindset. Let's take them with us. Then whatever further skill development has to be done, we'll create material for that. Not a problem. But the right people have to be doing it in mediation, and the programs that I see are not sending out what I feel is quality. I don't see that.
I hope that if this is applied in most countries, there will not be millions of mediators. I do not know how many mediators are acting now in India, but I can tell you that in Greece, which is a country of 11 million of inhabitants, we have almost 3,500 mediators.
That's, in our case, let me tell you that you can understand the size of the country. Of course, we are 1.3 billion people, and even we keep talking about the courts. We have 50 million cases pending in courts. We have 18 million which go into courts every year. Now we were discussing today, we had one of our senior mediators from India, we were talking, he was saying that he's looking at that at least 50% of the civil matters in the country, instead of going to court, should go for mediation. And these are the ones who go to court. There's so many more which don't even reach the courts. There's so many disputes out there. So even if you look at that, you're looking at maybe about, I would say 20. I mean, if you look at, let's just take it, I'm not even going to go 50-50, because if it's 50-50, then you're talking about, say, 9 million cases out there. Out of that, you take out civil cases. So that's the number of cases that you have. Look at the number of millions of how many people we need. So to get to that scale, we'll only be doing disservice to mediation by saying that, yes, we can train them, because they have to be people who are of that quality to train. So I've been saying that if you want to actually train in that sense, you have to give out some skill development, put it out on media for get the best in the world, and put it out television or wherever you have to put it, give the best to everyone, so that you know that they've been given that kind of quality of input, instead of trying to create training institutions. You don't know what is happening in those training institutions, what they're telling them. So I'm okay that you want to put out training, which is what I'm going to be doing. I did do some lectures about mediation, but now it's going to be a structured skill development program, which will be available to everyone to access. We'll get the best in the world to talk about mediation. They will take whatever you feel. We'll ask Catherine, what all do you want to cover in this? We'll identify the best in the world to talk about it. Let's do that for mediation. That side I'm okay with. But the moment you control these things and you have few people giving out these certifications, quality definitely suffers. The UK example that you gave, in the last symposium last year, there was Andrew Miller, who's from the UK. He says there are 18,000 certified accredited mediators in the UK, only 500 have worked. That's his statistics. Can you imagine what use is that certification doing to the mediation world either the user experience is not good or people don't want to use mediation. So both ways, it doesn't serve any purpose. So we have to be able to look at it from the user's perspective. I think the user is the only one who's got left out. That's the only one we don't take into account.
Indeed. Indeed, you're absolutely right. But your viewpoint is very interesting. I will keep it in mind. Article 5 of the directive provides the recourse to mediation following a relevant invitation of a court, where the parties are free to accept or to reject such invitation. The same provision is contained in the last law, the last Greek law on mediation, put into force in 2019. In the above Article 5, it is specified that mediation can be ordered, not proposed, by a competent authority of another state member. In paragraph 2 of Article 5 of the directive, it is provided that the directive applied subject to possible national legislation making mandatory the recourse to mediation, or linking the recourse to mediation with incentive or penalties, regardless whether it takes place before or after the commencement of the trial, to the extent that said legislation does not prevent the parties to exercise the right to have recourse to the courts. Here, I will make a reference to say that the issue of mandatory mediation is the object of many controversial opinions, as everybody knows. There are people, authorities, university professors, people knowing very well what they are speaking about, considering that mediation, if done compulsory, loses its essence, because the essence of mediation is that the parties are free to decide whether they will go to mediation, whether and how they will solve their dispute, and this process is governed by full free decision of the parties. The other opinion says that the fact to make mandatory the recourse to mediation is not contrary to its essence, because even if mandatory, mediation is an opt-in, opt-out procedure. The parties assume that they are ordered by a court to go to mediation. They go to mediation. 5 minutes later, they can leave the session without having to give any explanation for their attitude, and without any subsequent consequences accruing out of this. So why not? Based on that, the second Greek law, which was put into force in 2018, and mainly it is a very, very extensive law governing many matters, but Articles 178 to 206 of this law 4512 of 2018 provided compulsory mediation before the starting of the hearing of a case, even if an action was already filed with the competent court, before the action was heard, or before the action was filed, if it was not as yet, the parties had to go mandatorily to mediation. The cases were limited. It was cases for compensation due to car accidents, for claims for indemnifications accruing out of doctors and patients' relations, and family disputes, except those governed by dispositions of mandatory law, such as divorce or adoption. So it was very specific. There were 7 categories. As a matter of fact, Greece had followed the model, the Italian model. But due to an application filed with the Supreme Court, with the administrative section of the Supreme Court of Greece, by the union, the plenary union of bar associations of the country, the Supreme Court rendered an advice stating that these dispositions of the new law, which was to be voted, was anti-constitutional because it attracted additional financial burden to the parties due to the fee of the mediator and of the legal attorneys who, as a matter of fact, must attend mediation, all the process of mediation, together with their clients. And this is why this disposition was considered to be anti-constitutional. The law provided that after this compulsory session of mediation, if they presented themselves at this session, the parties thereafter could leave immediately. So this is what we said before. Still, it was an opt-in, opt-out process. Now, 1 year later, 1 year and a half later, Law 4640 of 2019 came into force in November 2019. And this law, in order not to take the risk to have compulsory mediation considered again constitutional, anti-constitutional, has regulated the matter in a smart way. They have done it the other way around. They said, either before filing an action with the court or after same has been filed, the litigants have to go into a first mandatory mediation meeting during which the mediator informs the parties about the principles of mediation, the process of mediation, and so and so, which is useless because they have been already informed by their legal advisors and so on. And if the parties decide so, at the end of said meeting, they can proceed to full mediation with the same or another mediator. So it is exactly the same thing as the previous law, but in another elegant way, formulated in another elegant way. Now, to be on the safe side, the new law has reduced the fees of the mediator and fixed them to 50 euros to be paid half by one party and half by another. Of course, this is not fair for a mediator, but at least it has opened the way to mediation because people become accustomed to mediation. They are informed about mediation and what it is. So if at the end of the first mandatory meeting, they decide that they will not continue to full mediation, they know what they are refusing because they have get in touch at least for 1 hour with this out-of-court method of settlement of the mediation. Now, the cases where the first mandatory meeting of mediation is needed, according to the Greek legislation now in force, is very broad. First of all, we have all the cases for which the one-member court of first instance is competent, provided the object is higher than 30,000 euros. Then all the cases for which the multi-member court of first instance, that is to say that the big cases, are subject to the first mandatory meeting of mediation, regardless to what is the amount. And also family cases, except those governed, again, by mandatory legal dispositions. I will go now to Article 6 of the directive, which provides, because it is accepted, almost unanimously accepted by everyone, that one of the reasons of lack of confidence of the people regarding mediation and the prevention of having it equalized in their mind with the court's judgment, as well as the difficulty to achieve the goal of the directive, being to ensure a better access to justice by means of the creation of a space of freedom, security, and justice, is due to the fact that the mediator does not render any judgment. So, to bring some remedy to this, to incite people to believe in mediation, and in order to create trust to mediation, the directive, as well as most of the legislation, have provided that any agreement, settlement agreement, accruing out of a mediation process can become enforceable according to the law of the state where the mediation has taken place. At this point, I would like to strengthen the way in which an agreement having accrued out of a mediation process becomes enforceable in Greece. It is a very, very simple way. When the mediation process is over, if the parties have reached an agreement, this agreement is included in the minutes drafted by the mediator at the end of the meeting, which are the only minutes drafted by the mediator. Thereafter, the mediator hands to any of the parties original copy of the agreement, and any of the parties without the contribution of the other, without the consent, even the consent of the other party, can submit his minutes to the clerk of the court, which would be competent to try the case if legal proceedings had been instigated. The clerk of the court gives this document to the president of the court, who affixes on it the formula, not the mandatory formula, the formula of enforcement, which is in the name of Greek people, this document is considered to be enforceable, etc., etc. And it is handed back to the person having submitted it, who can proceed to any to any enforcement, obligatory enforcement, provided the agreement contains regulations solve a dispute which can be the object of a mandatory execution, enforcement. Now, we could say that this is not absolutely, it is not absolutely in accordance with the directive, because the directive provides, as we all know, that the agreements having accrued out of mediation can be declared enforceable after an application filed either by both parties or by one party with the consent of the other, filed with a competent tribunal or another state authority who declares them enforceable. Consequently, the way in which Greek legislation regulates this matter could be considered to be contrary to the directive if there was not a point in the introduction of the directive providing that the way to declare an agreement having accrued out of mediation enforceable can be regulated freely by the state where the application for enforcement is filed. Now, as far as Article 7 of the directive is concerned, it sets forth the principle of confidentiality, providing that the member states must take care so, except if the parties agree otherwise, neither the mediators nor any other persons involved in an administrative way in the mediation process be not obliged to produce in civil and commercial trials or arbitrations data having accrued out of a mediation process or related to it. To my opinion, the words, the persons having participated in an administrative way in the process is not appropriate, because we all know that in the process of mediation, we have the parties, the mediator, of course, the legal advisors of the parties, possibly experts, possibly graphologists, possibly translators, possibly interpreters, by preference, not translators, and that's it. Who are the persons involved in an administrative way? I cannot see, but maybe there is an answer which I could not find. Anyhow, in Greece, it is provided also that the process is absolutely confidential, and the possibility is granted to the parties to extend the confidentiality to the agreement, to any agreement which will possibly accrue out of the mediation process, but also to the fact per se that a mediation is taking place. Because there might be businessmen who would not like that the market know that there is a dispute for which mediation is conducted. Exceptions are provided to the principle of confidentiality, both by the directive and by Greek legislation. They are exactly the same. It is the cases where confidentiality has not to be respected to protect the basic interests of children or to avoid the danger of harm of the physical or psychological integrity of a person, as well as when disclosure of the contents of an agreement accruing out of a mediation process is necessary for its application or its enforcement. Because of course, if I go to court to the clerk and I submit the agreement in order to have it declared enforceable, of course the clerk, the president of the court, and many other people, and when I will proceed to the enforcement, many other people, the court bailiff and others, will know what are the contents of the agreement. Another concern of people usually is that their claim could become time barred in case they go to mediation and they go then to court. Of course, under Greek legislation, there is an easy way to avoid this by filing the lawsuit with the court and having it served by court bailiff upon the opponent. Then the prescription is interrupted. But of course, this is an expensive way because to prepare a lawsuit, a lawyer must study all the files, possibly hundreds of papers, etc. And the fees of the lawyer will be high, possibly without reason, if the mediation is successful. So this is not the best way to proceed. And this is the reason why the legislation, both the directive and Greek legislation and many other legislations provide that when mediation starts, there is an interruption of the prescription and of the period of time within which the specific right becomes time barred. Greek legislation has provided to avoid that persons take advantage of that and extend the mediation for days and days and months possibly and have it fixed to another date and remitted by providing that mediation should be achieved in X number of days or weeks. Last, Article 9 deals with information of the public, providing that member states shall encourage by any means which they consider appropriate the availability to it, in particular on internet, of information on how to contact mediators and organizations providing mediation services. There are 3 more articles in the directive which are really of no interest. They are absolutely of an administrative nature. Now, let me tell you a few words about mediation in the penal field. ADR exists also in the field of criminal law. A recommendation of the European Council contains direction as to the use of mediation in criminal cases. In the frame of criminal proceedings, mediation has been defined as a procedure where an impartial mediator helps with the consent of both parties, both the victim and the perpetrator of the criminal act, to participate actively to the resolution of issues accruing out of the criminal act in question. Neither the victim nor the perpetrator should be incited in an illegal way to accept mediation by means of compulsion from the public prosecutor or due to lack of legal advisors. However, there are cases where mediation is prohibited in criminal cases, These cases are the cases of prevention and fighting of violence against women and the domestic violence, which prohibits the alternative dispute resolution by means, among others, of mediation and compromise. Greek legislation provides also in its article 303 of the Code of Penal Procedure, the bargaining plea in the field of penal law, which is, however, limited to the possibility of the accused person and his lawyer to ask for a negotiation regarding only the penalty to be imposed. The relevant application must be submitted no later than the formal end of the main pre-trial judicial investigation or of the preliminary investigation, and only for criminal acts pursued on the own motion of the competent authority, namely the public prosecutor. A very short mention of the European Code of Conduct of Mediators. The European Code of Conduct of Mediators is also a part of the European legislation about mediation. It is an important element of the European institutional frame regarding ADR. It was put into force in 2004. Yet, the above code is not mandatory. The application of its dispositions are not mandatory. It is, the mediators are absolutely free to apply, to follow its dispositions, and they have no any consequences in case they infringe or they do not apply, let's say, any of these dispositions. The code was presented for the first time during a conference held in Brussels in July 2004. In Greece, the Mediator's Conduct Code is composed of one ministerial decision issued by derogation of an article of the first law I mentioned, 3898 of 2010, and also by Article 18 of Law 4640 of 2019. According to a report of the European Commission addressed to the European Parliament in August 2016, that is to say 12 years after the Code of Mediators Conduct was put into force, the application of the directive in respect to the codes of conduct appears satisfactory. The Greek Code of Conduct contains dispositions almost similar to those of the European Code of Conduct of Mediators. And as I said before, the Greek Code of Conduct of Mediators is composed by a ministerial decision and by Article 17, not 18, of Law 4640 of 2019. These are the main points I wanted to share with you. I am at your disposition for any questions.
Look, Catherine, one of course,
that I will be.
Look, one definitely you have to take us through the fact that EU hasn't, I mean, the Singapore Convention, is it going to be signed by EU or the countries? How is that going to happen? What's the status on that? So a little bit about that, if you can tell us.
About the Singapore Convention?
Yeah.
We will definitely sign it, no doubt. And this will facilitate a lot the enforcement of the agreements accruing out of mediation and will eliminate any possible contestation of the lawfulness of the dispositions governing the way in which an agreement becomes enforceable in Greece as opposed to other legislation of other member states or of the dispositions of the directive itself.
But what is the reason right now? Why is it being delayed? Why is Greece is going to? I mean, what is the situation between the European Union and Greece? How is that working?
No, there is no problem. There is no specific problem. And while we are speaking, possibly the convention has been already ratified. Give me 1 second and I will give you the answer. It was signed, as you know, in August 2019 and opened for signature. And the same day, and it was put into force on the 12th of September 2020.
Yeah.
But this does not answer your question.
No. No, because I really wanted to understand what is really happening behind the scenes. What is, I mean, is there some discussion between the European Union on it, or is Greece thinking of doing it on its own? What's really happening there? I mean, what is really stopping them? Because look, if all the countries in the European Union sign it and ratify it, it definitely helps. It definitely helps. So you're saying there is some discussion happening. That's what you're saying. There is some discussion in Greece to sign it? To sign
No.
Okay. The other thing, Catherine, what you really have to address is that all legislation and everything, according to me, revolves around the inefficiency of the judicial system. That inefficiency directs everything, all the mandatory and everything. I just don't want mediation to develop on that basis, because you talk about access to justice and then you say mediation is access to justice. Some people talk about that. My concept is that every time mediation is going to be promoted because the courts are overloaded and they can't do their job, a foundation will be a problem. And then you'll always keep coming out with these mandatory and the costs and everything. And at the end of the day, if I'm sitting in a mediation, and which we do tell the parties, look, it's going to take another 10 years, maybe 15 years. We tell the parties that. Now, to settle something because a court case is going to take 15 years is the worst thing for mediation. You're not doing it because you understand what mediation is or how good it is in relation to settling something. You're doing it because a gun has been put on your head. It's as good as that. So I don't think that's the way to promote mediation. And I think that's where things have gone wrong. People are connecting again with the court system. Like I said, there was the last symposium, there was Chuck he's from Israel, who's based in Germany now. And he said that the court system in Germany is so efficient that mediation is not popular. While in Israel, it's popular because the courts are inefficient. So mediation should not develop because of the inefficiencies of the courts. They have to take care of that. Don't connect it to that system at all. because you'll always keep coming out with, okay, first meeting for so many euros, and you can do this. At the same time, you have to look at from the party's perspective. Like you said, the lawyer's fee is one aspect of it. You're just creating a barrier in between something which they should be able to access, yes. And if they're not accessing it, what they are getting is a compromise which they don't want to really do. I don't want. Okay. I mean, you're someone who's supplied goods to someone, and you have to get your money back. That's as simple as it for that person. But because you can take 15 years, say in a country like ours, it can take 15 years. So you say, okay, let's just do this. I don't really want to do it, but I have to do it because of that. That's not mediation. I mean, that's just, it's a way of blackmailing someone. And to develop mediation on that foundation, I think that's the worst thing that's happening. I don't know what your thoughts on that are.
And what would you suggest, Vikram?
I'm saying totally disconnected from the court system, totally explaining the fact, all the advantages that we want to talk about, whatever the things are. First of all, look, Catherine, we have to also put it across as we go along that you have to have value-based negotiations. Everyone talks about interests and all that. What about values? Societies have to start looking at value-based negotiations. They have to, like I keep saying, the humanistic approach and all that. Let's take mediation onto that category. Today, we are talking about mediation only in relation to the courts and all this, this mandatory and cost and all that aspect of it. It puts mediation in a totally different light for the user. It's not a good thing for them. It's like being forced into something. They let them find value in it. That part of it is how I would want mediation to be taken forward. People have become so engrossed in the way mediation has been taken for only for the interest of the judiciary. It's only for the interest of the judiciary. The judiciary in every country is the most inefficient institution. No one questions it because they're the judiciary. And this is the way people have gone on for years. Judges and the judiciary can do what they want. Question them. You become efficient. If they're not becoming efficient, what is the reason for it? Is there a problem in your law? Is the procedural law creating a problem? Is not enough judges for you? What is all that? Question all those things. But do not put people into a process because you are inefficient. People have to question that aspect of it, which is not being questioned in countries, because judiciary is getting away with it. Today, if mediation is being given for almost free, what value are we putting for the user? It's a free service. What do you pay? I mean, today, if I as a person is going to quote a fee to someone, what is the comparison? If they go to the court system and look at the fee there, this is what the value of a mediator is for them. What are we doing to mediation and mediators? Finally, we want it to be something that a mediator should be able to practice on a full-time basis. Then you can call it a profession if you want to call it a profession. But if you don't want to do that and you want it to be a service which is free, and the mediator should rise above all that and should have no needs of their own, no livelihood they require, they are only going to do the larger service. So today we had someone in one of the sessions in the morning. He says, people say mediation is a public service and all that, but should not. That's why you shouldn't get paid for it. He was saying, aren't the judges doing public service? Why are they getting houses and cars and salaries? Isn't that a public service? So, I mean, I'm telling you, the foundation somewhere is so wrong, and we keep getting totally dragged into it because that's the discussion. That's the only discussion that takes place. I'm saying, judiciary, let them be. Today I was telling this person, because I don't work in the court system at all, but he works in the court system. I said, please tell all the people all the mediators in the court system, you are not going to do any work there until you are not allowed to set your own fees. And otherwise, just let it go. It's not helping mediation. 17 years we've had mediation in the court system in India. Nothing has happened for mediation outside the court system. Only bad things have been said about mediation. I showed this person an interview of a mediator who's saying the mediator will decide. He's saying the decision of the mediator. This is a person who's trained and working in the Supreme Court of this country. So it's not gone in the right direction through the court system, because some statement someone made, if you give peanuts, you'll get monkeys. What kind of things are we saying about mediation? I mean, it's just not the right thing that's happening. So I'm just saying, Catherine, please question all that. If you have to look at legislation, I give the example of the Indian legislation, which people say in India, we don't have a legislation on mediation. And I say we have the best legislation on mediation. It's called conciliation. Have a look at it. And because it's called conciliation, because we picked it in 1996. Imagine we were so much ahead of our times. Everything that you require in a legislation is there. Confidentiality, without prejudice, mediator not being called for a witness, all there. But on the other end, total flexibility to the parties, whom they appoint as a mediator, however the process happens, totally on them. Finally, that conciliator, let's call the conciliator signs that settlement agreement. It's as good as a court decree. You don't have to go to court. You don't have to do anything. So imagine the empowerment of a person sitting in a village in India. You can understand our population, 60% is rural population. And similarly, in lots of countries, it's like that. So that larger picture, I think no one is either seeing it or they don't want to see it because the judiciary is blinded everyone on it and no one questions the judiciary. We do not want mediation to develop because the judiciary is inefficient. I don't think that's the wrong step to take. Foundation will always be weak. We will always face problems as we go along because we're dragging the judiciary. It's just dragging us down. That's all it is doing. It's not benefiting mediation at all. It's never benefited anywhere in the world. The mediator has suffered. In the court system, mediators have totally suffered. They're not getting what they want. So what you're pushing out, there's a very senior mediator in Nigeria. In one of the sessions, one of the lectures on mediation that I did, he was talking about feel inferior going into a court where you have the lawyers with all their wigs and their gowns, and you are getting, he gets for the entire mediation will get $40. That's all. And he's a senior mediator. I mean, senior, very senior lawyer. He says the parties look at me differently. They said, oh, this guy gets as much as a clerk. Their attitude towards him is different. How would you do a mediation in this kind of thing if the parties don't have respect for you? It's not good for the mediators and mediation. It might be good for the judiciary. We're not here to take care of the judiciary. They have to take care of themselves. So I think we have to question all that. I don't know how you look at it.
It is a very interesting viewpoint. I take note of it, and no doubt I will discuss it with members of the Central Commission of Mediation at the Ministry of Justice, because it is very, very intelligent. We should not drag people because the other way is bad.
Yes.
We should convince them that our way is good.
Absolutely. That's really well said, Catherine. Really well said. You put the gist of what I said. I did my ranting, but you put it in a very nice way. So that's exactly what it's all about. It's as simple as that. That's exactly what we have to put across. And that's what no one puts across, because on the other side is the judiciary. And nowhere in the world people want to take up the judiciary because of course they have their power and they've done whatever, they get away with it, no one questions them. So someone has to do it, and in every country they have to do it, because if we want mediation to develop in the right way, I think that seems to be, for me, the direction that we have to take. And the mediators have to see the long term for them in that. It's a long term thing, because we know that on the other end the process works, people benefit from it, the good user experiences are there on the other side, but the whole thing goes into a totally different direction for the user also. So definitely that part of it we need to question and discuss, and you are the best person to do it in Greece. The other thing, Catherine, is the aspect of state bodies not being party to mediations and governments wanting to keep them away. We have to really look at some solution for it, because on one end, definitely there is a problem for the government, because corruption is one issue that a lot of governments face. And to be able to have a bureaucrat or anyone getting into a settlement agreement which will compromise the government's situation, I can understand the government having a reservation there. But we also need to find a solution, because a lot of countries, the government is a major litigant. In India, it's the biggest litigant. Government is the biggest litigant. So if we can take care of those matters, so there was one discussion that we were having that if there is a body that can be created, whoever is respected, say the judges of the retired judges are respected, make a body for them who can look at settlement agreements. And once it goes to that body and there is a certain time period given for the body to get back whether the settlement agreement is all right or not, if they don't get back after a certain period, the bureaucrat or the government official who has signed it, then there is immunity for that person. I think that we need some kind of, this is one solution that we were looking at, but if there should be something that we should be discussing on that end, because we need to bring that into mediation. So anything that you have, any thoughts that you have on that?
To my opinion, as I said before, the disputes where the state has acted iure gestionis, meaning as any physical or person or legal entity, without making use of his public authority, should be submitted to mediation.
But we only have to also consider their situation, that because it is something where corruption is an issue with countries. So there is definitely an issue. I was talking to someone from Kazakhstan. Yeah. Because the countries have given their...
Why should corruption be an obstacle in the specific matter?
Because finally the government official is going to settle the matter. So definitely that part of it, if it is binding on the...
Okay. I see your point. Okay.
Yeah. Because what has happened is that while...
Interesting viewpoint. I shall mention it again.
Because I tell you, when the Singapore...
Now, may I ask you one question, please?
Yeah.
You said that in India, you have the compromise by legislation. It is exactly the same thing in Greece. And I wanted to know if the conciliator, after having conducted the process of conciliation, makes the party find a way to settle amicably their dispute. This agreement has not to be ratified by the court.
No, it's as good as automatically, because look, the thing is, we've put it under our Arbitration and Conciliation Act we've got. So because at that point of time, that was the understanding that now this is as good as a consent award. So the settlement agreement becomes as good as a consent award, which is as good as a court decree. So that's the route it was taken at that time. Today, I'm saying you can keep it separately as the settlement agreement directly becomes a court decree. You don't have to go through the arbitration, because the thing is, when you were making the legislation, you also had to give grounds to the court to refuse enforcement. So the grounds that are taken are the same which are for an arbitral award. So it was through that. Today we have the Singapore Convention. We have a model on mediation. Easily you can take it as a separate legislation. But the thing I've been discussing, a lot of people maybe don't understand that. I've been trying to put across. We need both the words. We need mediation and conciliation for the reason that if you are in an arbitration and you want to settle the matter and you want to stay in the arbitration, you cannot suggest a legislation which takes you out of the arbitration. Because otherwise, then if you settle the matter, you can't come back to the arbitrator, because the matter is already settled. There is no dispute. So the arbitrator cannot pass a consent award. It won't be right. Then you will not get the benefit of the New York Convention. So if you want the benefit of the New York Convention, you call that mediation. You stay in the arbitration, call that mediation. And if you want to go out of the arbitration, call it conciliation. So both the words are required. You've got under the conciliation, you're getting as good as what is a consent award. It's as good as a consent award. So you don't have to come back to the arbitrator. It becomes a court decree. If you want to stay in the arbitration, you settle the matter, come to the arbitrator, he passes a consent award, you stay, you get the benefit of the New York Convention. So we have to be able to explain that both the words are required. Here, people are not being able to understand that. Same thing with the court system. In our civil procedure code, both the words are used, mediation and conciliation. So if you want to stay in the court, you call that mediation, you stay in the court, that settlement agreement goes to the judge and you get a court decree from there. But if you want to go out of the court system and you want to settle it through conciliation, the advantage of that is then you get the benefit of the Singapore Convention. If you stay in the court and you get a decree passed by the judge, you can't use it in the Singapore Convention. You can't enforce it under the Singapore Convention. So these are things people have to understand that both the words are required. People are not being able to understand that. They're falling for this trap. Oh, we don't have a law on mediation. We don't have a law on mediation. Then they keep talking about the word doesn't matter. The UNCITRAL in its model law has so nicely clarified this, that we use the word earlier. Now we're using the word mediation, but mediation is conciliation and any other word of the same import. It doesn't matter. So that we have to look at those definitions, give the larger picture to people. I think people are still not being able to understand either the larger picture, or they don't want to look at it and create issues later, as these issues will come up later. Because definitely you don't, I mean, everyone doesn't, today with the Singapore Convention not so popular, people would still want to use the New York Convention. So they would want to stay in the arbitration. So by using a word which only has one meaning, which is a mediation law, an act, mediation act, supposing you use the word mediation, then you go only under that act. Where is the other option? So I think that way, I think we need to also explain that there has to be some larger understanding. I don't know your thoughts on that. I mean, these are my thoughts which I put across. I mean, I don't know how you look at it.
Vikram, I'm convinced that you should write an article about all what you have said now, because they are very, very instructive. Would you do this?
I'll tell you, Catherine, the problem has been that I keep putting so many shows and events out. There is not ever a minute to do anything else. That's why I put it out, that people, if they agree with me or they have similar thoughts, they should write, they put it out to their countries, have that discussion within their mediator community. Because the thing is, I'm telling you, there has been a very narrow approach, because for me, as I understand it, because it has all been focused on this court system and legislation there, and people have been totally talking about that and lost sight of mediation, according to me. The larger picture of mediation, no one even is talking about that. They're getting us so involved in these discussions. I just want, look, there's such nice mediators in the world. This is the fact that they can practice. I just want them to practice this on an everyday basis. They're so passionate about it. And the people, we know the user can benefit, and to put it out in a nice manner, and to be able to tell them. Today we had a session on transformative mediation. Baruch Bush is someone who proponent of transformative mediation, talking about nice things, how you transform the parties. And the whole concept is totally different. And on this end, it is all, mediation connected to the court, lawyers being involved, this happening, that happening. I think we've taken it to the wrong direction, and it's about time we get it back on track as what mediation should be. And that is why, again, I'll go back to that symposium of last year, mediation in our culture and traditions. Connect people with the process, not the word. Don't alienate them from the process, because that's what's happening. They think it's some other thing, some technical thing you are going to do, some rocket science you have, or what is happening here, something different is going to happen. No, nothing different. You know about the process, you know everything about the process. Now we just have to, if we have to create a framework, if a legal framework, then I'm telling you, look at our law, the best. Nothing complicated. Protect what needs to be protected. Give flexibility where it has to be given. I call it the colonizer's mindset, that the state and the judiciary should be involved in dispute resolution, in every dispute resolution. No, we have the court system. That is one part of dispute resolution. Keep that there. There is dispute resolution which has to happen on a regular basis, otherwise also. This whole thought process, dispute resolution, you use the terminology and courts come in front of you. Why don't you talk about mandatory arbitration? I never hear anyone talking about mandatory arbitration. Look, talk about them and give them the same amount as what you give to a mediator. I'm telling you that the same day, all that legislation will be scrapped. The lawyers will make sure that all that is scrapped. This is just because mediators are decent people. That's what is being taken advantage of. So I think we have to do something there. I think, because for me, I'm telling you, it's always people say mediation, promoting mediation. I've always said, you read my posts, I always say mediators and mediation. Don't take mediation out to talk about mediation without the mediator, because mediation doesn't happen without the mediator. And that's the only
Indeed.
person who's been left out of the process. Everyone else has been discussed. The self-interest of the judiciary has been discussed. How can lawyers benefit from it? People have been saying, look, lawyers today get their decent fees in the mediation. They have nothing to complain about. So they've been looked after. Judiciary is looked after because matters are going out. They're very happy. Who's the ones suffering? One, of course, the mediator. The other, the user, because the user is being put through something which actually is being forced down on them. And like I said, inefficient judiciary. Make the judiciary efficient. I don't want, like I said, I don't want mediation to develop on that basis. That's the worst way. It will never develop. It'll always be something that you are being forced into to settle only because of that. And that will always stay in your mind. And whenever you talk to someone, you will always say, I just had to get into this settlement because it was going to take 15 years and the lawyer's cost and all. So I settled. So you didn't do it willingly. What use is a settlement agreement which is not willing? People say that, yes, settlement agreement has been done by you. Yes, it's been done by you, but did you willingly want to do this? No, you didn't willingly want to do it. You wanted your share, whatever you were supposed to get out of that. But so Catherine, these are the issues which I have a total different thought process on this. So I will not drag you into it because I do this ranting all the time. So I don't want to drag you through it. But I've sent you the links. I've sent you both the links to Kristen Cherenji's session on his CRET experience. I've sent you that. And I've also sent you the link on LinkedIn. I've sent you the YouTube links on the Socrates and mediation also. So you've got both the links. You have something to watch. So you have some hours of viewing time available to you. And keep telling me what topics you're interested in. I'll send you the links to those YouTube videos because there's so much content. There are more than 350 videos there. So how do you keep a tab on it is something that you have to do. Maybe you can go to my website, mediatorvikram.com. I've tried to put an index out, tried to put down which video is what. There are links to the video. Maybe you can look at it there. So there's a lot of interesting content there.
Okay.
Yeah. So any closing remarks that you want to give, please, you can, whatever you want to close the session on.
I just wanted to tell you that I will give you the answer. I can tell you that the Singapore Convention has been ratified by 46 countries. And I will give you in writing the answer, whether Greece intends to ratify it shortly or not.
No, the thing is right now, only 55 countries have signed it and 10 countries have ratified it. Only 10 countries have ratified it yet. So, and out of those countries, I've actually put it down on my website. There's a section on Singapore Convention, which is of course taken from the official, the UNCITRAL site. So I put it down there. Basically, these are 55 countries signed. There's a link to what the status is. But the important thing, like I was telling you, that Belarus, Georgia, Iran, Kazakhstan, and Saudi Arabia have given their reservation that it will not apply to the government if government is a party. So to that extent, that's one thing which will, of course, always be a discussion. So these are the countries which have ratified it. So that process is happening. And the good thing, I think, Catherine, is that while countries are ratifying the Singapore Convention, at least they'll start looking at their domestic law. So that's the important thing. So at least mediation comes in the focus there. So that's the good thing that's happening. Yeah. So thank you very much, Catherine. Lovely talking to you. I know that I dragged you. I did a little ranting there. So
I wish you all the best. Hari Om.
Thank you. Hari Om and Namaste. And please drop in tomorrow if you get time for the last session or 7 o'clock India time.
Okay.
Yeah. Thank you very much. And I'll see you then. See you. Thanks. Bye.
Thank you.